Hi there and welcome once again to Employment Hour in 30. I'm John Scholes, your host, my co-host Lior Samfiru. Today we'll have your partner on the show as well, Sivan Tumarkin, doing the long-term disability angle of the law firm. That's coming up a little later on. This show about severance, workplace rights, and everything that concerns you in the place you spend probably at least 8, possibly more hours a day for 30, 40 years of your life. It's a very important show. It's an important topic, so we get to all kinds of things on the show. 1-855-821-5900 is the number to call the firm anytime. EmploymentHourTV.ca as well, and emails, which we'll get to a little later on. help@employmenthour.com as well. Lior, we start every show with the week that was. What do you got for me?
Well, John, it was a week where I got actually a lot of good feedback on our show. People that have watched our show and told me that it's helped them. They found out about their rights and solved some of their problems. And this is great. This is exactly what you and I hear every single week, to talk about those rights that people have at the workplace. Maybe you have a problem. Your boss did something, said something to you. Your work was changed. Your job was changed. Maybe you lost your job. You need to know what your rights are. That's why we're here, to educate people. There's so many misconceptions out there about workplace rights. I hear those every single day. It drives me crazy, which is why we're wanting to educate people here on this show. So if you have a question about your workplace rights, tune in. You can always contact me off show hours. We'll give you our contact information many times throughout the show. And to get us revved up and started, let me tell you, John, about a matter that has come across my desk over the past few days. So this involved a gentleman who had been struggling with a medical condition. And because of that, he had to go to regular doctor appointments. Sometimes he'd have to miss work because of the doctor appointments. Sometimes he'd have to come in late to work. Sure. Nothing unusual, and he was dealing with it. And he was still working. And his employer never really said anything, never gave him a hard time. He didn't really communicate with his employer about it. And on this went for about 2 or 3 months. Well, after about 3 months of this happening, he gets called into a meeting with HR. And the company says to him, well, you've been missing all this work. You've been coming late. That's unacceptable. You've had all these instances. We've tracked it down. There's been 15 over the past few months. We're going to let you go. That's unacceptable. And that's, the company says, cause. Well, this gentleman obviously was taken aback. I mean, he hadn't had any warnings. He hadn't had anything to give him an idea that that's going to come. And he called me, and he wanted to know, can they do that? Well, John, here's what I told him. I said, first of all, because there's a legitimate medical reason, the company has to provide you some flexibility, some accommodation. Sure. They have to allow you to miss work if it's for legitimate doctor's appointment. And it's on them to ask you, why are you late? And if they need some corroboration from a doctor, to ask for it. So that's number one. So right off the bat, what the company did is wrong. But beyond that, if the company's going to let him go for cause because of being late or absences, they have to give him some warnings. They can't go from 0 to 100 without taking the steps in between. So they would have had to talk to him, give him some warnings, maybe even a suspension, before they could consider a termination for cause. So this company decided to jump the gun and forego all those steps. So this made it a wrongful dismissal. So the lesson here is very important. If an employer is going to terminate someone for cause, they have to engage in other discipline first. They have to provide warnings. They have to provide an opportunity to the employee to improve. They can't just decide, we don't like it, this is bad, we're going to let you go for cause. And of course, if there's a medical issue as to why your performance, your attendance is not what it should be, the employer has to understand that, provide accommodation, and they can't punish you because you're sick.
Is there something the employee could have done rather than just let this linger for 2 or 3 months? Should he have been a little more proactive, possibly, even though it's wrong on the part of the employer, right?
Listen, John, hindsight being what it is, of course, if he had spoken to me back then, I would have told him, if you're going to miss work, tell your employer there's a medical condition, give him a note, absolutely. But there's an obligation on the company to ask for it. Right. They can't just ignore it and then, after a while, decide, now we care. If you want to know why he's late, if that's unacceptable, ask the question. Find out if there's a legitimate reason. So it really does go both ways.
And again, if he has the backing of a doctor and medical professionals, that trumps all, right?
It trumps all. Doctor always trumps. If your doctor says you can't work or that you need accommodation or you have to be late, the company can't do anything about it. They have to allow you to follow your doctor's orders. And if they don't, that could be a human rights violation.
You can check out EmploymentHourTV.ca to find out where we are on as far as radio show is concerned, which has been going on for years. It's very popular. We do it every week, a bunch of shows. We get a ton of phone calls as well. People asking questions about this, about severance. And we'd like to get to a few of the calls on the show here this morning, today, and let you hear what they're all about. Here's one of them right now.
I suspect my company may downsize in the near future, and I've been there for 6 years, and I'm just curious what I should do to protect myself how I can maximize what I receive. What's the best step if I'm concerned about a future potential downsizing?
Right.
There you go.
It's a good question. I get that quite often when someone sees the writing on the wall. They understand that they're probably going to be let go, and they want to know, how do I protect myself? How do I put myself in the best position to get my severance when they let me go? Well, the reality is, John, that a person's termination entitlements are assessed and calculated as of the date of termination. There's not much that you can do to improve your future severance. But here's some words of advice if you think you're going to be let go. Number one is, just because you think you're going to be let go doesn't mean it's time to start slacking off at work. You don't want to give the company reason to try to say, we have cause to let you go. Well, they're going to let me go, so I'm not going to show up. I'll do a very bad job. No, that's a bad idea. Don't do that. Continue working, doing the best you can. You may want to get a copy of your employment agreement. Have that handy, because we may need to look at that employment agreement if they let you go. If there's a bonus plan document, even an employee manual or handbook, have that handy. We may need to look at that once they let you go. The other thing you want to do, and just to start planning and thinking about what severance would look like, go to Severance Calculator, severancepaycalculator.com. We'll talk about that more later on the show. And find out how much you're owed so that you start to think, okay, I'm going to get 12-month severance, 18-month severance. Well, you can start thinking about that. How long is it going to take you to find another job? So all those things you can do. But the most important thing is, just because you think you're going to be let go, don't give the company reason or thought or even the idea that they should be letting you go for cause. Do your job. And the most important thing, this is key. If they let you go, you don't sign anything.
Yeah.
You don't go on a message board. You don't call the Ministry of Labor. You give me a call. I'll review the severance package. If it's not fine, we'll improve it. Not a problem. If it's fine, great. But 90% of people, John, 90% of people are offered a lot less than what they're owed.
Basically, get your ducks in a row before it happens. Even if it doesn't happen, you just might want to know anyway, right?
Absolutely. You got to be prepared. And the most important thing is also think about what that severance looks like. Go to Severance Calculator and assess your entitlements.
Help at employmenthour.com is the email. 1-855-821-5900 is the number anytime to get a hold of Lior, a member of the firm. Terminationquestions.com as well. This is a very interesting website. Again, it's been around for years. People can go there. They have a question. Maybe they don't want to call in. Maybe they haven't got time to use the Severance Pay Calculator. Questions of all types, forms, and sizes and fashions for that matter. People will ask there. There's a drop-down menu. Chances are your question has been answered before, but just in case it hasn't, leave it at terminationquestions.com, and you or a member of your staff will get to the answer fairly quickly. We'll get to one here. I'll give this one to you and see what you think about this. I've just been told that my job as a programmer analyst is no more. My boss said that he's going in a quote-unquote new direction, but is willing to give me 1 week's pay for the 2 years I worked. I left a perfectly good job of 19 years to join him at his request, and now I'm out of work. I'm 2 years shy of 60, so it will be tough to find a new tech job. Wow.
Tough situation. Can you imagine you leave a job and, with the best of intentions, and now shortly after you find out you're out of work and the company's going to give you 1 week's pay? Well, not so fast. It doesn't work that way. This situation is what we may refer to as inducement. If you leave a secure job and you join another company because they came after you, they asked you to do it, they were the ones convincing you to leave, well, what happens in that situation, if that new company turns around and lets you go, they may have to account for your previous service.
Yeah, he had, 19 years?
19 years when it comes to your severance. So you may have only worked for the company for 2 years, but if you've worked with the previous company for 19, when it comes to calculating your severance, you may be a 21-year employee. So it's very important. The difference is going to be huge. Now, for this particular gentleman, even if he's only a 2-year employee, he's going to be owed a lot more than a week's pay. He's probably going to be owed 5-6 months of severance. Yeah, absolutely. But he may well be a 21-year employee. So let's take his situation and plug it into our handy-dandy tool, the Severance Calculator, and see what that gives us. So he's a program analyst. If he has 21 years of credited service, he says he's just shy of 6. He's 58 years old. I used a salary of $75,000. Sure. He was offered 1 week, according to this email that we got. Well, he's owed, as the Severance Calculator would show, 18 to 22 months' pay. And the difference, John, is somewhere north of $111,000. And this is a common situation. Can you imagine being offered $111,000 less than what you're actually owed? That's why it's so key to tune in here, to understand what your rights are, to use the Severance Calculator, and never accept something without doing your due diligence. There's a lot of ways where the law provides for more severance than you realize, a lot of ways. And if you don't realize that, you may end up accepting pennies on the dollar for this person. If he hadn't asked the question, if he hadn't found out what he was owed, he'd be shortchanged into the six figures. That's horrible.
And that's the shame of it. This happens hundreds, if not thousands of times a day, and companies are literally saving tons of money by paying out minimal severance when they shouldn't be.
Individuals don't know any better.
Yep.
And sometimes the information out there, if you'd say you go online, can be confusing. That's why we wanted to be here and simplify things. It's actually not complicated. It really isn't. But you need to have the right sources of information giving you that advice. So Severance Calculator, call me if you're not sure. If you know someone that lost their jobs, have them give me a call as well. We can always help.
EmploymentHourTV.ca, again, the website if you want to find out a radio station near you where we host the Employment Hour and have for several years. We get a lot of phone calls on the show every week, and I want to get to another one. Let you hear it.
I'm considered a subcontractor at where I work. However, I work for the same company. I don't work for anybody else. I drive a company vehicle, and I'm being told that because I'm a subcontractor, I don't have to get paid for stat holidays, and I don't get overtime pay. I want to know if that's true or if I'm just being lied to.
The old contractor question.
The old contractor question, John. And you know, you and I can probably do this show for another 10 years, and I'm pretty sure every show will have a question like this. And this is very, very common. I get these questions all the time. Individuals often get misclassified as contractors when they're really employees. So it's very simple. If you have a regular job, you work for a company, you go to their premises, you're an employee. It's that simple. It doesn't matter what you call yourself. It doesn't matter what the company calls you or what they want to call you. You are an employee. So it does seem like this gentleman that just left us the voicemail is an employee as well. So what does that mean? Yes, it does mean he's owed overtime and statutory holiday pay and vacation pay. The problem here is to pursue those aspects, statutory holiday, vacation, overtime, etc., he would have to file a complaint with the Ministry of Labor and have the Ministry of Labor order his employer to pay. Now, how that's going to damage his relationship with the company, it's for him to say, so it may be uncomfortable to do that. So he has to decide whether he wants to do that. But what I can say is because he's being misclassified, if at some point the company lets him go, he's going to get severance as an employee, well, because he is an employee. So at that point, the company may say, well, you're a subcontractor, you don't get severance. That would be wrong. Because he's an employee, he'd be owed severance. He has to give me a call. In the meantime, yes, is he owed overtime? Absolutely. He has to decide whether he wants to pursue it. But this is a classic situation of someone being misclassified when they're really an employee.
You know, we always say if it's just that simple, then nobody would ever hire anybody because you'd be avoiding severance. It'd be simple. Why would you hire anybody at your law firm?
Absolutely. I would never have an employee. No one would ever hire an employee if you could just call them a contractor. It doesn't work that way. The law decides that. You don't decide, I don't decide, the company doesn't decide. The law takes care of deciding whether someone is an employee or a contractor, and so many times people get misclassified, and that's especially important when they're let go.
Help at EmploymentHour.com, 1-855-821-5900 is the number. We'll take a short break. We'll get to the Severance Pay Calculator when we come back and what to do when you're denied long-term disability. Stick around for that. It's coming up, Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. The contact anytime, help at employmenthour.com, 1-855-821-5900 or employmenthour.ca as well, employmenthourtv.ca, pardon me. Severance Pay Calculator, we love this tool. It's been almost 5 years. About 400,000 plus people have used this with much success. Give me some details on it.
Yeah, we're getting close to that 500,000 mark of people using it successful. It's unbelievable. So it's a tool that I created when I realized people accept inadequate severance because there's so much misinformation out there, and I wanted to avoid that. I wanted to make sure that people have the information that they need if they lost their job to make it easy so they don't have to worry about calling me or they don't have to worry about getting a hold of someone. Everyone should have access to that information. So severancepaycalculator.com and severancepaycalculator.com. You answer 3 simple questions: your age, your position, and the length of your employment. It takes seconds. And by the way, it's anonymous. It's completely free. You don't have to put in your name, your company's name. It's strictly there for your information. And you find out in seconds how much severance you're owed. So if you think you know how much severance you're owed, and if you think you know whether your severance offer is fair, trust me, it's not fair, and you don't know. Go to severancepaycalculator.com, check it out, find out how much you're really owed, the real number. Not what the minimum entitlements are, not what the company wants to pay you. And of course, if you know someone that lost your job, your friend, your neighbor, your brother, your sister, tell them to go to severancepaycalculator.com. Once you're armed with that information, you will not be taken advantage of. And that is the key here. That's why I created it. severancepaycalculator.com.
There's an employer mode on there as well, so if you're an employer, you can also look and hedge your bets as to what you're going to owe somebody if you're thinking of letting them go. Plus, people always contact you after going through the calculator. It takes 30 seconds and go, wow, this is like an early Christmas gift. This is way more than I thought it would be. There's got to be a bug in the system. It's not how it works.
No, there's no bug in the system. And yeah, I guess it could be an early or late Christmas gift, depending on your perspective. But yeah, it's accurate. And the reason why you may find that it's more than you expected is because people believe these wrong concepts of a week per year or 2 weeks per year. That is wrong. It's not that at all. Oftentimes it could be 5, 10 times that. That's why the calculator is so important. It is accurate. So always go to severancepaycalculator.com.
Someone sent us an example here. I'll read this out, and you can put it through the machine. It says, Dan has worked as a professional at a company for 5 years, making $52,000 at age 46. After an illness, he can no longer perform his duties, and the company does not want to reassign him to a more suitable position. They've offered him 1 week per year of service, there you go, plus 2 weeks retiring allowance for a total of 7 weeks pay. Is that okay?
Well, the problem here, even before we talk about severance, is the fact that if he has a medical condition, the company has to accommodate him. So I want to mention that right off the bat. They can't decide, well, too bad, you do your old job, you don't do anything at all. It doesn't work that way. If they can accommodate him by putting him in a different position, then they have to. Otherwise, it's a human rights violation. But now let's talk about severance. So if he's been there for 5 years, 46 making 52,000, they've offered him 7 weeks. So if we were to plug that in our handy dandy severance calculator, it would tell us accurately that he gets anywhere from 8 to 9 months pay. Months, not weeks, months. So he was offered 7 weeks. He should have been offered 8 to 9 months. And that's a difference of anywhere from $27,000 to $32,000. Now, John, the reason why we brought this particular example forward is not because it's unique. In fact, we brought it forward because it's not unique. It's common. It's what we see every day. So by using the severance calculator, by finding out how much he's owed, he's going to be able to get another $30,000. That's why it's so important. That's why you have to use it. And if you're not sure, if you believe that your offer is fair, do yourself a favor. Don't do me a favor, do yourself a favor. Go to severancepaycalculator.com.
Email as well, help@employmenthour.com, 1-855-821-5900 is the number. employmenthourtv.ca if you want to check out where you can find us, or at least hear us on the radio show every week for about the last 4 or 5 years. A ton of phone calls every week, and we'll get to another call from the show now.
I work for a construction company, and this company is going through hard times, and they're about to do a mass temporary layoff. I know about the 13 weeks if somebody has no benefit. Before it gets considered termination, number one question is, am I correct to assume so? And number two, this company being in the construction business, are they allowed to temporarily lay off?
Construction business.
Construction. You know, a lot of times, John, people believe that different rules apply in construction. And for the most part, at least when it comes to severance, termination, there's no different rules. So his question was about a temporary layoff. The only time he could be laid off temporarily legally is if he's been laid off before. So if there's a past precedent, past practice that the company has established and that he accepted, then they may be able to lay him off again. But if there isn't, if this is the first layoff, the company, whether it's construction or otherwise, does not have the right to lay him off temporarily. And what I mean by that is he has the right to treat that as a termination and say, no, I'm not going to accept that. I'm not going to sit at home for the next 15 weeks and demand his severance right now. So that's what I want our viewers to understand. A temporary layoff, unless you've been laid off before, a temporary layoff is a termination, whether you work in construction or otherwise. So because of that, if you've been laid off temporarily and now you're not going to be earning any income, maybe it's better to get your severance and then look for another job. The problem with accepting that layoff is if you accept it and you come back to work assuming they even call you back, is you give the company the right to do it again and again. And can you imagine now, all of a sudden, every year you get laid off for 6 months? That's not a way to live. That's not a way to work. So that's why it's better if your employer is going to start laying you off temporarily to say, no, that's not acceptable. I want my severance, and I'm going to move to a different job. And of course, that's my job also, to help you get that. So if you've been laid off temporarily, definitely give me a call.
You know, another thing that often goes hand in hand with employment law is disability law. That's why the brilliance of your firm, you do both, not just employment. In that regard, Sivan Tumarkin is your partner. We're going to have him on the show. If you've been cut off from long-term disability or anything under there, stay tuned. We're going to tell you what to do about it, how to go about doing it with Sivan as a partner of the firm. Coming up, 1-855-821-5900 and help@employmenthour.com. Lots more Employment Hour in 30 coming right up.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact: over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
All right, welcome back to Employment Hour in 30. Part of what you guys do at the firm is not only employment law, but it's also long-term disability insurance law as well. Sivan Tumarkin, partner of the firm. How are you, pal?
I'm great, John.
Good to have you back in the show. Basically, just give us the P's and Q's, the quick list of what you do at the firm and how it works.
Well, my group deals with long-term disability, and we talk every day with people who've been denied long-term disability, cut off long-term disability. It's a very, very stressful time. Not just for the disabled people that are being cut off and denied disability, but for their families. No money's coming in, they have no idea what to do, and they feel like they're being re-victimized essentially, because they're dealing with their disability, and at the same time they have to deal with this billion-dollar company that's telling them they're not entitled to the safety net that they thought they were paying into. So we help them.
And this often goes hand in hand with employment. You'll find someone who's not only been on disability, but now they've lost their job as well. So you guys go back and forth all the time.
100%, 100%. I can tell you as a fact, every day I have employment lawyers in my office, and I'll go into Lior's office and we'll talk about it. And people are being laid off, and at the same time they're dealing with their insurance company and they have no idea what to do. And here you have us. We do both things, and we maximize whatever it is that the individual is owed by both the employer as well as the insurance company.
EmploymentHourTV.ca is where you want to go to find out where you can tune into the radio show, Employment Hour, anytime during the week. We do it about 4 times a week, depending on what station you're listening to. We got a ton of phone calls, and a lot of those have to do with LTD as well, because, again, they mesh together so nicely. Let's get to one of those calls, Sivan.
My wife recently had surgery on her back. There were some complications, and she has to stay off work for a while. Now, she's been on long-term disability for over a year, and now the insurance company is telling her that she has to go back to work in a few weeks, or they will cut off her insurance. She can't go back to work. That's what her doctors are saying. And now her employer is also saying that if she doesn't go back sometime soon, they will fire her and replace her. We really have no idea what to do.
See, this is where it all comes together again, right? So what does she do?
This is very, very interesting and something that we get all the time. Now, here's the interesting thing about this case. She's been told by the insurance company that if she doesn't do something, she will be cut off. Yep. So she hasn't been cut off. And many people are in that situation where they are told, you haven't been cut off, but you will be. That's when you call me. You don't wait until the time when you've been cut off, no money's coming in, and then you're trying to figure out, well, how am I going to pay my mortgage? How am I going to pay, for groceries? Oftentimes, we can intervene right there and then, and we will take the burden off your shoulders. Remember, as soon as we get involved, we are dealing with the insurance adjuster.
They can no longer contact you, right? That's
once we are in the picture, they are no longer allowed to call you, to email you, to send you letters. Absolutely not. We take the fight to them directly. And trust me, having done insurance defense in the past, having represented insurance companies, the last thing they want is a lawyer, a disability lawyer, knocking on their door, because that's when they know that they're going to have to spend more money on defending the claim, so they'd rather try and resolve it right there and then.
Same phone number, 1-855-821-5900 to get a hold of Sivan or Lior. Fightformyltd.com. This is a great website, similar to terminationquestions.com. If you have questions about LTD, if you've been denied, if you're in that battle, if you want to get a hold of Sivan, ask him a question, fightformyltd.com. I'll get to one here, a very common question. I'll let you answer this, Sivan. It says, what happens if the insurance company doesn't believe that I'm truly disabled despite my doctor's diagnosis and denies or cuts off my insurance claim? What do I do?
So this is, again, a very interesting thing because it happens all the time. So first of all, I don't care what the insurance company believes. It's not up to them to decide if the individual is disabled. It's up to the treating doctors. So I'll have people calling me and telling me, listen, my orthopedic surgeon or my neurologist or psychologist, whoever it is telling the insurance company, has written them saying, I am disabled, I'm not able to work. And the insurance adjuster says, nah, we don't believe you. Or we've had our own doctors take a look at these documents and we don't believe you. Call me. Trust me when I tell you that it's not as difficult as you think to push back, but you have to understand how the insurance company operates. See, they make money in one of two ways, collecting premiums and denying claims. Right. And they'll assume that the majority of people out there, once they deny you your claim, that you'll simply walk away. And many people do that.
They're playing the odds, right?
They're playing the odds. And as soon as we step in, the game changes. And remember, you're not dealing with them, we're dealing with them. You can actually focus on your health. Do exactly what your doctors are telling you to do. Don't do what the insurance company is telling you to do because that's actually going to make you worse. Give us a call, email me. You know, at the very least, I tell people, call me when you have these issues. It'll cost you nothing to talk to me, and we can give you your options. And how you wish to proceed after, that's up to you, but at least you'll be armed with the information you need.
Again, fightformyltd.com. You want to ask a question anytime that will be answered very quickly by Sivan or a member of his team. Another one says, how many times should I appeal the insurance company's decision to cut off my long-term disability claim before giving up? I laugh because we go through this all the time.
We do. And you know, one thing people need to understand is that when they get a denial letter, a letter from the insurance company saying we've denied your claim or cut you off, one of the last paragraphs in that letter says you can appeal this decision. Remember, if you're appealing that decision, you're essentially
you're asking the same people who cut you off.
It's exactly that, exactly. I mean, the power is still in their hands. So the answer is zero. Right. Zero. You don't appeal. As soon as you get denied, or even if you think you're going to get denied or cut off, you give me a call. You do not appeal these denials. These are detours, and they're engineered to frustrate you and, you know, to make sure that you're in a position down the road where you simply don't have, you know, the stamina to fight. Instead, you give me a call, we have a discussion, and I'll tell you what, you know, your rights are and what your options are.
It's not only a matter of stamina, it's a matter of if they keep sending you for another appeal, eventually if you go past that 2-year mark, you're done, right?
You got it, and that's very important because in Ontario we have a 2-year limitation period, and, you know, and that starts running from the first time you got denied or cut off your disability payments. And sometimes, you know, people appeal 2, 3 times, maybe even more, and by the time you speak to me, you know, you tell me, well, I was cut off 3 years ago. It's too late at this point. It's extremely important that you give me a call or email me as soon as you either get cut off or denied, or if you think that that will happen. Don't wait until it happens. If you see, you know, red signs, if you have a gut sense that there is a problem, trust me, there's likely a problem. You'll hear the adjuster's tone changing. You'll sense that there is something that is going on. You're told that they want you to see one of their doctors.
Which you have to do.
Which you have to do. Okay. But, you know, again, there are caveats. Make sure you give us a call. It'll cost you nothing to talk to us, and at least you'll know what your options are.
Lior, we often talk about, you know, when we do the show together, that there's so much symbiosis between the two of you guys in the firm that they often go hand in hand.
Happens all the time. Someone gets cut off disability, the company hears about it, and they say, well, now you've been cut off, you have to come back to work, or else in the meantime you're just following your doctor's advice. So we could deal with the company, get them off your back, and of course get your benefits either reinstated from the insurance company or get your additional compensation. These go hand in hand all the time, every single day. So that's why Sivan is here. That's why we deal with both these things. So if you have a problem with your employer or your disability insurer or both, you just give us a call.
Done for another week. Again, contact. You want to talk to either Sivan or Lior anytime, 1-855-821-5900. It is help@employmenthour.com through email, fightformyltd.com as well to get a hold of Sivan and his side, and employmenthourtv.ca. You want to find out anytime, catch the radio show, you can do that as well. Again, next time right here, Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.